Hello friends, Namaskaram, how are you? Har Har Mahadev, Jai Shiv Shambhu. In today's class, we will discuss one of the most important query of the accused, which is concerning the application to be filed or yet to be filed as per the protocol of section 94 of BNSS. As we know that whenever you are going to allege that the case of prosecution is not fair, the evidences are compromised, and more specifically, the call locations are doubtful. In that scenario, with intention to summon the call location and CDR, the application as per the protocol of section 94 of BNSS had been submitted or is submitted. But in absence of scope and effective knowledge, we are not in a position to contest the application effectively. And many of the applications used to be rejected by the concerned court. So basically, we have to understand the fundamentals so that whenever we are going to submit the application, it could be as per the norms. Concerning the scope of section 94 of BNSS, we have to understand one of the most important judgment of Honorable Supreme Court, which is titled as Varshagar versus State of MP. In that case, Honorable Court observed that if a document is relevant or requisite in a case, the court has to summon it, and court has to accord the opportunity of fair trial or investigation to the concerned accused. Based on the same analogy, recently Honorable Himachal Pradesh High Court had pronounced a verdict which is dated 5th of March 2026. In that case, an application had been submitted by the accused as per the protocol of section 94 of BNSS. In that case, in the application, it is submitted and requested by the concerned accused that call location and CDR is to be summoned. But the application had been rejected. The possibility might be that the pleadings are not proper, or there might be a prayer by the accused to summon the CDR or call location. I want to clarify that recently we are having two judgments. One is of Honorable Delhi High Court and other is of Karnataka High Court concerning the cases of Prevention of Corruption Act. In both the cases, court observed that the prayer could be submitted regarding the preservation, not concerning the summoning. If there is a prayer regarding summoning, in that scenario, the applications are liable to be rejected. But both the judgments are concerned up to the stage of investigation. So basically, whenever we are going to submit the application and the case is under investigation, we have to consider or keep in our mind the said protocol. Whenever we are having a case as per section 7 of PC Act, and we are having the allegations that the case is compromised, and apart from that, the evidences are concocted. In that scenario, while moving the application for section 94 of BNSS, we have to specify our stand. In that case, the stand of the accused was that he was arrested at 11:30 am, and as per charge sheet, it is shown that there was a call between accused and co-accused at 1 pm. So if the accused is arrested and mobile phone has been taken from his or her custody, in that scenario, it is next to impossible to have a call subsequent in time. So when the stand is clear, so we could easily submit the point of relevancy. In that case, the accused submitted not only his call location, but also the call location of team along with CDR is to be summoned. The prosecution opposed the application on ground that the case is under investigation. The proceeding might be hampered. But Honorable Court specified that the opportunity of fair trial or investigation must be inclined to the accused. But the key requirement is that the accused has to show why the document is requisite. So when the stand is clear and relevancy is clear, in that scenario, the application deserves to be allowed. The court further observed that every court in our country is bound to discover the truth about allegation. So basically, if the allegations are specific and it is duly corroborated by the circumstances, in that scenario, the applications could be inclined. So finally, the court inclined the order in favor of accused. So whenever we are going to move the application, we have to emphasize on 5 segments. Number 1, the facts of the case. Number 2, the cause of action. Number 3, why documents are requisite or relevant. Number 4, how the documents would be helpful to rebut the presumption and to create a suspect. Because as we know that the court could not create the evidence. Apart from that, the court could not participate in all the proceeding concerned with collection of evidence. But whenever the court finds that the prosecution had compressed the scenario and it is duly evident by the situations so put up by the concerned accused in that scenario to discover the truth concerning the allegation, the applications could be inclined. So I think that I have specified you how to work out and what will be your strategy. See you in the next class. Till then, Har Har Mahadev, Jai Shiv Shambhu.